So a New York gun licensing case has made its way to the Supreme Court, which could be a game changer. So let's talk about this. But real quick before we jump into this video, if you think it's time for the Supreme Court to finally uphold our Second Amendment rights, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main supporters of the channel, and that is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. Also, I want to let you know that this content is powered by the Firearms Policy Coalition, so head on over to joinfpc.org to join the Second Amendment fight. Thank you again, Firearms Policy Coalition, for supporting this channel. So in this video, we're going to be talking about a New York gun licensing case that has made its way to the Supreme Court, and it is Abekassis v. New York City. So some background on this case and how it found its way to the Supreme Court and what it all involves and why it's so important. This was a lawsuit originally filed back in 2019 after New York City denied an individual named Ralph Abekassis his application for a license to keep a handgun in his home. His application was denied because he was deemed ineligible and unfit to possess a handgun in his home for self-defense based on an arrest he had back when he was 15 years old. And this was a case which essentially was not prosecuted at all, and the New York City Law Department actually declined to prosecute him for that issue. He was also denied the gun license based on the fact that he failed to make timely payments on some fines that he had in the city, and he also had some other non-criminal kind of infractions, and also that he had a bad driving history. So all those things compounded together, and then the city of New York denied his gun licensing permit for him to have a firearm in his home for self-defense. Now, in reviewing this case, a district court judge ultimately dismissed his lawsuit against the city, and then he filed an appeal up to the Second Circuit. While the case was on appeal to the Second Circuit, the city of New York all of a sudden decided that they did want to grant him that license. And they did grant him that license, and then they went back to the Second Circuit and argued that the Second Circuit should actually rule that the case is moot now that the city has given him the license. And then on review, ultimately the court and the judge did find the case to be moot and kicked the case, and the lawsuit died there. Well, now you actually have the plaintiff here. He is appealing up to the Supreme Court and is specifically about some of those issues about how all of a sudden the Second Circuit has mooted his case just because the city of New York has decided to give him his license right after he filed a lawsuit against them. In his cert petition to the Supreme Court, he's arguing that this case is not moot and should not have been kicked because he will still need to renew his license every 3 years, and New York City is now free to deny him for the same reasons that caused the lawsuit to even be brought initially. Now, why this case is important is because in the past, the Supreme Court has found a Second Amendment challenge to New York laws moot because the laws were changed after the case was brought up to the Supreme Court. And one of the concerning things that a lot of us speculated once the Supreme Court found that case to be moot is that the city of New York and other states would then use that strategy going forward to try to get other Second Amendment challenges and cases kicked out. And that's exactly what's happening here. Now, in the cert petition to the Supreme Court, there are two questions presented. And the general statement of what's going on here is that in New York State Rifle and Pistol Association v. City of New York, this court held that New York City's post-certiorari amendment to the challenged handgun regulations mooted the petitioner's claim. So that was that prior case that the Supreme Court had mooted, and we were all very much concerned about the fallout that would happen after that case. In this cert petition, they go on to state that, emboldened, the city continues to orchestrate the manipulation of judicial review of unconstitutional firearms regulations in violation of the Second Amendment. The city's repeated and wrongful conduct and the Second Circuit's disregard of it give rise to this petition, which cries out for an exercise of this court's supervisory power. So essentially, this case is arising out of the mess that the Supreme Court made when they mooted that last Second Amendment case. Now, there are two questions presented to the Supreme Court. The first is whether, based on the court's jurisdiction as articulated in two prior cases, the Second Circuit erred in dismissing this case as moot, where New York City's calculated and repetitive actions were designed to evade appellate review. The second question presented is whether New York City's post-filing unsolicited issuance of a firearms license moots the live controversy where the licensee remains subject to the challenged regulations. Now, there are two main arguments that are presented in the cert petition of why the Supreme Court needs to review this case. The first main argument is that the case was and is not moot. In the cert petition, the plaintiff states that this case was not moot because he has not been provided with any of the relief sought in the complaint. He did not seek the issuance of a discretionary handgun license. Rather, he sought to strike and enjoin the challenged portions of the law in a declaration from the court that the regulations violate the Second Amendment and his rights. So there, essentially what he is saying is the Second Circuit found his case to be moot when the New York City issued him the license. But he was not seeking in that challenge, in that complaint, for New York City to issue a license to him. He was seeking for the Second Circuit and also the district court below to find that this whole scheme and permit and licensing requirement be found invalid. And the fact that New York City issued him a license does not moot and does not satisfy what he was actually looking for in that lawsuit. Also, he states that he remains subject to the same discretionary licensing scheme he has challenged. He goes on to say that the city has as much broad discretion to revoke the license or deny its renewal as it had in granting the license in the first instance. So just because the city issued the license when the case was filed does not change the fact that they still have the discretion under the law to pull his license whenever they want, or to even deny his license renewal at any time under the same basis that they initially denied his license. He goes on to state that it is well settled that a defendant's voluntary cessation of a challenged practice does not deprive a federal court of its power to determine the legality of the practice. However, New York continues to use this actual strategy, and the court, including the Supreme Court, need to stop allowing the city of New York to do this to circumvent appellate review of what is clearly an unconstitutional violation of the Second Amendment. Now, the second main argument presented in the cert petition is that this is a continued practice to prevent review of 2A violations. In this section, he argues that not only is a city likely to repeat its behavior to him, if left unchecked, the city will continue to engage in its pattern and practices of enforcing unconstitutional regulations, making public policy arguments in defense of its regulations, and then abandoning those very arguments by issuing a license rather than risking a bona fide appellate review. So essentially he's arguing there that if this is not reviewed by the Supreme Court, this will lead to a pattern in practice, not just in New York, but other areas as well, where these unconstitutional laws will be passed based on claimed public policies. Then once they are challenged by various individuals in appellate courts, they will just say, hey, we were just kidding. We're going to issue the license or we're going to revoke that law to avoid the actual review of those laws, and pretty much just trying to circumvent the entire judicial system. In this section, he goes on to give an example of another case in this very same area where a man was denied a rifle and shotgun license. That individual challenged the denial, but when it got to the appellate process, the city suddenly offered him a license if he would drop the case. So the argument here is that there is plenty of examples that the city of New York is clearly manipulating the court process while the city is also violating 2A rights. And they're doing this because they can get these cases pulled once they are brought, but it doesn't actually change what they're doing because all these individuals are still going to be subject to the licensing schemes and various Second Amendment infringements. All the city has to do is say, hey, we're going to back off when there's a case. They get the case thrown out, and then they just continue doing these same practices until another case is brought up. So if you guys have any questions, go ahead and comment down below, and I'll try to answer the best of my ability. Also, if you like this video and like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It signals to YouTube that you guys see value in these videos, in this type of 2A news, and then it pushes it to more people. Recently, on the last video, Al Gore's rhythm was definitely not for us. There were a lot of YouTube issues with that video, and they pretty much just shut that video down. So if you guys can like, comment, and subscribe on this video, drop a comment down below that you're coming to fuel Al Gore's rhythm. Hopefully we can get this video some traction and get this really important news out to more people. So if you don't have a comment in mind, just comment down below that you're coming to fuel Al Gore's rhythm. And also I want to put on your guys' radar that I recently started a secondary channel, and it's going to host the podcast and all that other stuff. So all the information on that, if you're interested in listening to the podcast when I released it, all that information is down in the details section. So as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, this is with Built by Arm Scholars, and it's nationally maintained by Arm Scholars.